From WKNOW, this is Steve Chanley with One Question Too Many. Today's guest is attorney Thomas Vidal of the Los Angeles law firm of Pryor, Cashman. With over 25 years' experience, Mr. Vidal has established himself as a go-to trial lawyer for high-stakes litigation, often coming into a case shortly before trial. Today's programming is made possible by the law firm of Employer Advocates Group, serving employers throughout California with offices in Orange County and San Luis Obispo. eaglawgroup.com. So hi, Tom. How are you today?
I'm great. How are you?
I'm well. Thanks for joining us today.
Glad to be here.
Tell me a little bit about your practice.
So my trial lawyer, as you know, and my practice is primarily, I guess the best way I describe it are financial injuries. I represent people in fraud cases, in infringement cases, copyright, trademark, whatever that might be. But any kind of cases that involve somebody that's been financially harmed, CEOs that have been pushed out of their companies, founders that have been pushed out, those are the kinds of cases that I deal with.
According to your firm's bio, your current practice is primarily entertainment and media disputes?
Yes, that is what it says on the bio, but my practice is evolved quite a bit. So we're actually working on some modifications. But yes, the bread and butter of my work has been historically entertainment related work, copyright infringement, motion picture cases, that kind of thing, cases involving financiers. But because of the interrelatedness of the entertainment, IP issues, the finance issues, my practice ended up broadening a little bit. So, for example, I represented people that have been in disputes over the financial transactions. Again, that's largely came out of the sort of scope of work that I was doing for the entertainment industry. The substantive work is very similar in a lot of ways, but it's grown a lot broader.
That's interesting. When you first began practicing law about 25 years ago, what was your practice area at that time?
That's a good way to back into this question. So I started out doing entertainment. I had a mix of transactional and litigation. And then I had a variety of other cases because when I got out of law school, I started my own practice. So there was a component of I was developing the practice that I wanted to develop, also needing to work and do what came in. So I handled a variety of cases, employment cases, defamation, those kinds of things. And frankly, while many of those cases are outside of what I would describe my wheelhouse today, those things were really, formative in a lot of ways of developing, number one, how I handle cases and how I think about the law and giving me a broader base to work from.
Along the way as a trial lawyer, have you had the benefit of mentoring?
I do have some mentors. So I'll tell you who I consider my mentors to be. But I never had a trial lawyer that I worked under that was a mentor because most of the partners that I worked under when I joined firms didn't try a lot of cases. One of them did, but by the time I was working for him, wasn't trying a lot of cases. And his name was Marvin Gelfand, and he was actually really good in shaping my idea about how to develop cases and build them. So I would consider Marvin a mentor. The people that had much more involvement in shaping me were in my trial practice professor when I was in law school, a lady named Carol Chase, and the two coaches of my trial team, Tim Perrin and Harry Caldwell. And then in terms of practitioners, because I didn't have anyone close enough to me to tell me, hey, this is how you do this and this is what you should do, I reached out and tried to broaden my ability to find mentorship. And one of the people that I consider premier in that group, although he doesn't necessarily know this, is the attorney Fred Bartlett of Bartlett Beck. I read a book about, a case that he'd handled called the trial. His case was talked about in this book called The Trial Lawyers. And I followed him after that. I emailed him a few times and he was gracious enough to respond to me. And I always liked what I've read about him, how he handled his cases. Steve Sussman, I read about him in a book called The Litigators and tried to model myself after things that these kind of trial titans did, how they handled cases, how they thought about cases and those kinds of things.
How important do you think it is to have mentorship as a fledgling trial lawyer?
I think it's critical. And from my own experience, yes, you can pull yourself up by your bootstraps sort of thing, but you're far better having somebody who can mentor you. And I have done quite a bit to take what I've learned and share it with the people that work for me. And for one example, I spent, I don't know, probably the last 4 years or so developing a trial practice academy that I now launched this year, and I'm training my own associates. 2 of them have tried cases with me, so they've been through it and seen it up close and personal, but to actually be more methodical about explaining my views about stuff. And what I've tried to do, because maybe your experience, there's so many different styles of trial lawyers. You can't make cookie cutter trial lawyers. We're all different, and we bring our own passions and ideas and thoughts about how to try a case. So I try to be instructive about how I've done something, but to tell people how to think broadly and to put their own imprint. This is what's worked for me. Try it. But when you're in the hot seat and you have to rely on your own gut and your sense of the situation, don't be doctrinaire about it. So that's sort of my teaching philosophy about things, because I think you equip people the right way and they're going to make good, educated decisions, but you want to equip them in such a way that they know what they're thinking about and how to reason about a case and case strategy and persuasiveness and how to apply that in any given circumstance where they're on their own.
How important do you think it is for a trial lawyer to have their own voice?
I think that's critical. But I think every trial lawyer is a unique person, and they think about and reason about how to explain case facts and persuasive theory differently. And I think you do need to have your own voice to be effective. I don't think copying somebody else. Yes, you could copy somebody's closing statement or some argument or some language that they might use. There's nothing wrong with that, but you have to personalize it and make it you.
How important do you think it is for a jury to actually like you as a person to be an effective trial lawyer?
Also a very good question. I don't know. I have not been able to pull enough juries to try to figure out how they actually think about the attorneys involved in the case. I know the times that I have talked to the juries afterwards. There was a case that I had a few years ago where both opposing counsel hit well with the jury. Like if they were to go out for a drink after the trial with one of the trial lawyers, they would have a hard time deciding among us. I think we both had kind of rapport with the jury in that sense. So I think in those cases, it's not an easy thing where the jury just, I like this lawyer, I'm going to find for his side. But I do think jurors try to separate how they feel about an attorney, how they feel about a case from the facts of the case when they're deciding it, in my experience. But I do think charisma is important, but I don't think that's it. I think it's the lawyer's credibility and commitment to being the fair and honest guide through the facts is what the jury's looking at when I think about whether a jury, likes someone or not, is, can I trust this person? Are they leading me down the right path? And I think that aspect of that credibility piece is what makes all the difference in the world.
So it's more a question of how credible you are than how likable you are, per se.
Yeah, I do think the things go hand in hand. They don't, strictly speaking, but I think largely they break down now.
Do you think that someone who naturally doesn't have good interpersonal skills could still be an effective trial lawyer?
Yes, I think you have to work at it. I think there's some work that needs to be done, but I don't think just because you're, say, introverted, that makes you a lesser trial lawyer. And this goes back to your question about how do people need to establish their own voice? Some people are, theatrical and bombastic, and that works. Some people are very reserved, and that works. Ultimately, you don't want to bore a jury. You want to be able to tell the facts in a compelling way that keeps them awake while they're listening to all this testimony. That doesn't necessarily require a showman, but it does require somebody who's thinking about the jury and thinking about developing testimony in a way that's appealing to them. And one of the reasons I think that's especially true is take direct examination. On direct examination, the lawyer is guiding a witness through testimony. The lawyer, yes, there is a very important role for a lawyer to have signposts and direct the jury and make sure that they're paying attention to important things. And sometimes that takes a little bit of flair. But mostly what you're trying to do is get the witness, direct them and guide them into telling their story in a compelling, engaging way. And that's done through prep and other things. And if you do your job in prep right, the witness should be the star of that process, with you, again, guiding them and pulling out the testimony that you need. And that doesn't require flamboyance or, somebody who's super charismatic.
I've heard it said that the best direct examinations are where the examining attorney is almost transparent in the process.
Yeah, I agree with that. Except I have one caveat about that. I think I think the lawyer who knows and has developed a very good, solid theory of their case, the lawyer should be the director and know the story that they're trying to tell with the facts that they have, and make sure that they shape the witness's presentation of the testimony to cover those things. But that doesn't contradict the other part of the lawyer staying in the background. Direct the questions to get the material that you need, but let the witness be the star. And I do think that's important. Juries, in my experience, definitely want to hear from the witnesses. They like listening to the lawyers, but they want to hear the facts from the mouths of the people that experience them.
Just generally speaking, when you're preparing one of your witnesses to testify, are there any tips that you give them to have their credibility be right on the surface that would somehow resonate with the jury?
Yeah, the number one, the first thing I make sure that is drilled, as you know, anybody who's going to sit in the seat is going to say, is make sure that they tell the truth, that they're committed to being honest and forthright. There's too many. I mean, in our cases, once they get to trial, we've been through so much, like depositions and other things. So this message has been conveyed. But once you get them to understand, look, tell the truth. It's perfectly fine to speak candidly about the situation. We know the good facts. We know the bad facts. We know how to deal with the bad facts. Every case that gets to trial has facts that are not favorable, and we're going to deal with them, and we're going to deal with them forthrightly. So be comfortable doing that. So that's number one. Number two, your job as a witness is to just be, in a sense, a tour guide. You're telling people what happened, what you experienced, where what happened when, this happened next, how those things got to be, and you just have to tell the story and be yourself. I try to prep witnesses in terms of the facts, and I don't want witnesses, a lot of witnesses that live them, especially our clients, throughout the life of the case, you hear them tell the story of the case, and, these witnesses, like you may hear the story 10 different times. The client never tells you their story differently. They know it back and forth. And what you don't want them to do is to be so over prepped thinking about the dynamics that that their own facts escape their memory. So what I do is I make the client tell the story. I have them tell the story that we're going to hear on direct. Like if I've arranged my direct a certain way, but when they talk about the story, they tell it differently, I don't rearrange them to conform to my direct exam. I rearrange my direct exam to conform to how they talk. So the first thing, make the witness feel very comfortable. Make them understand, we know what the facts are. We know what we're dealing with. And all you have to do is tell the story. And if there are problem facts that we're going to introduce through direct exam to, get ahead of them or make the jury understand that we're not holding back, we deal with them as like forthrightly as we can.
Is there ever a risk of over-preparing a witness?
I do think there is, and I've seen that happen where a witness feels like when you're working on a direct exam with a witness and you tell the witness, I'm going to ask you this question and this question and this question, then sometimes the witness can get this thing in their head like, oh, there's this sequence of events and I have to answer this question right, and they're not thinking about how they're going to answer the question naturally. They think they have to answer it in a certain way, and that's devastating because then you have a witness who either forgets large blocks of important facts or, just sort of locks up and then filibusters on the stand. None of those things are good. So what I try to do is prepare the witness. The witness has told me the story. It's the witness's story. The witness has been deposed. We've talked through things before, and we talk through it to make sure that they're, I don't know how you want to say that they remember all the milestones and the things that they wanted to talk about. Oh, you've told me this in the past. And then make them feel, I know I said this before, but just to make them feel comfortable. And I think if you can get them to deal with the nervousness and the emotion and that they just get to tell their story, you're not going to overdo the preparation. I don't think you need, it's depending on the client's interest. Some clients are very interested to know the elements of the causes of action, those kinds of things. And I think it's great to talk about those things. But I think you should do, in my own view, keeping that kind of light and just spending time with the witness, enabling them to talk about the facts in an organized way.
Do you ever sometimes instruct your witnesses to have eye contact with the jury to maybe establish some type of a nonverbal rapport with them?
I tell my witnesses to spend as much time looking at the jury as possible. You're talking to the jury, you're not talking to me. So I do spend a lot of time making sure that they do that. And, it's a valuable thing to have the client have rapport with the jury or all of your fact witnesses. I don't mean to just talk about it in terms of clients. By the same token, on cross-examination, we try to break that eye contact as much as possible and distance ourselves so that the witness has to look directly at us when they're responding instead of looking at the jury. But yeah, I like my clients and my witnesses to talk to the jury.
So I'd imagine it's your practice to poll a jury after a verdict has come back.
Yes.
Have you ever received feedback from the jury specifically about how the witness interacted with them nonverbally?
Yes, but they're not usually that direct about it where they would say, oh, I love that the witness looked at me. But what you can tell is witnesses that do spend time trying to communicate with the jury as if they're having a conversation with the jury. And that's an important distinction. It's not good to tell the witness just look at the jury, but talk to the jury as if you're conversing with them. And when you see that, and there's this level of comfortability of somebody telling their story and relating the facts to the jury, I think the juries welcome that, appreciate it, and I think it has a very good effect on them. I had a jury in this case that I had in September. They talked, when we got to talk to the jurors after the trial, they referred to my client in that elder abuse case had Alzheimer's. So his daughter was she was in trial and she was our first witness. And they talked about her by her first name as if they were buddies in that sense. And I think it was because of the rapport she established with them on the witness stand. Same thing with one of our experts who was a law professor who was talking about standards of care and those kinds of things. There was an attorney malpractice cause of action in the case as well. And they felt the same way about him because he talked to them like he was he wasn't lecturing to them. He was speaking to people that were sitting, a few feet from him. And yes, I think it has a good effect.
How important is it for witnesses, particularly expert witnesses, to use plain language when they're testifying?
I think it's important. But I also think I've had some juries where the people on the stand are engineers and scientists and people that are very comfortable working with complex vocabulary. So I don't have some blanket rule, don't use big words. But what I try to tell people to do is use the words that you naturally use. And if you think that there's some, as we're going through prep, if it seems like a word that a jury might have trouble with, I have them define the word. And sometimes that ends up being like part of the not part of the theme per se, but part of our messaging is like to take some word, to define it, to remind them what the definition might be of that word later on, so that they can, this is a word you may not have heard before. We're going to talk about, whatever it might be. Vicarious liability. That's a strange thing. What's vicarious liability? And then that they've got an association. It's not just that they've heard an alien word or alien phrase. It now is tied to something, maybe that's got a little bit of, humor or something else to make sure that they remember that fact. So I'm okay with big words if they're used in the right way and there's not, a sequence of 100 of them. But, I just tell people like talk the way that you would talk to a family member and use precision where it's necessary to communicate, who and what or where, but use the easiest words that you can to communicate that. I think sometimes people try to be too folksy and they say, talk about defining words like I was a few moments ago. They try to define words that maybe most jurors probably actually know or define a concept somebody might know, and they define it like they're talking to an elementary schooler. I think that does not play very well. I think the better approach is to assume that every member of your jury is very smart, very capable in paying attention, and talk to them like they're adults. And then, anything that you think is tricky, explain those things, but explain them in a way that doesn't, like you said, doesn't sound like you're talking down to them. Okay, we're using this concept. Many of you might know what it is, but some of you don't, and some of you might not. And this is what it means. And do it plain spoken and move on. So the more you call attention to it, I know that sense about what you're talking about, like the way a kindergarten teacher might explain a new word in a book to the kids, right? Like it's a little too much. And I think it feels insincere to the jury too.
Right. So I'm going to ask you a few questions about cross-examination.
Every trial lawyer's favorite subject, right?
Well, if that's the essence of trying a case, that's really where the crucible is. There's been a lot written, probably a disproportionate amount of ink spilled on the relatively small slice of a trial having to do with cross-examination. It seems to be the thing that holds the fascination of most people. My children will tell you that when they were growing up, they were often cross-examined.
Mine cross-examined me back. I think I've gotten my just desserts.
So what are some of the most valuable lessons that you've learned as a trial lawyer when it comes to cross-examination?
Well, I think for me, and maybe this is consistent with other trial lawyers, when you're learning and even when you get into this, cross-examination can be the most intimidating part of what we do. Or maybe it's not that it can be. Maybe it is the most intimidating thing that we do. And I have a theory as to why. In motion practice, we're talking to the judge. In voir dire, we're talking to the jury. In our opening statements, we get to give a largely uninterrupted speech to the jury. And even if it is interrupted, it's not with the other side telling their story. They're objecting for a variety of reasons. Closing argument, the same thing. And in direct examination, as we talked about just a little bit ago, the witness is the star, not so much the attorney. In cross-examination, you're dealing with a non-friendly witness who wants, the opposite goal of what you want for the most part. And you've got your client there who wants you to, tear them down on cross-examination. You have your colleagues, maybe. You have the other side that's expecting, has all these expectations on you. And it just feels like there's all this pressure involved in cross-examination. I think the lesson to learn, first of all, is when you learn the methodology of what you're trying to do in a cross-examination and how you're trying to do it, it diminishes that fear, because the objective is to get out facts that are key to your themes and theories of the case. So when you know that you're doing that, and we can explore that in a little bit more if you want, but when you understand what the goals of cross-examination are, it makes it a little less stressful to prepare a cross-examination that gets out the things that you need. So, for example, you might want the witness that you're cross-examining to state a fact that the jury hasn't heard yet that's important to your case, right? So, and that might not be an admission. Maybe that's the witness was at a certain place at a certain time, right? So that's an important fact to get out perhaps for your case. Or you want them to admit something that they can't deny, or you want them to highlight certain facts that they've testified about that favor your theory of the case as opposed to theirs. When you understand what those narrow goals are, and you realize I don't have to have this witness break down on the stand and admit that they're liable, it changes how you view cross-examination, and I think it makes the whole process a lot more methodical, at least in terms of developing the kinds of questions and goals that you have for the particular witness.
Have you developed any techniques for controlling a difficult witness?
I have, and I'll tell you about them. But when I started out in undergrad as a computer science major, and I switched over to political science when I decided I was going to go to law school. And when I was sitting down for my very first examination in a major class in computer science, instead of reading my data structures and algorithms book, I was reading The Art of Cross-Examination by Francis L. Wellman. And as I'm reading this and I cannot stop turning the pages, I realized what I wanted to do with my life. So yes, cross-examination is the lore that we all love and that draws us to what we do. So the best technique that I have, and I can tell you I've developed these techniques, not, what I'm going to say is not anything, Tom's got a new lock on cross-examination. I watched and learned from others, and I watched and learned from others because I got beat up on cross-examination a whole bunch of times. I asked the open-ended question that allowed a witness to drive a truck through the answer and think to myself, that was a big, big mistake. I can't believe I just did that, And fortunately, a lot of times, somebody gets out an answer that you didn't necessarily want them to go retell their whole story on, and it doesn't ultimately matter at the end of the day, but, sometimes it's really problematic. But it was through getting, kicked in the teeth, as it were, a bunch of times that I realized, the questions I asked a lot of times that I thought were leading questions weren't really leading. They were questions that were more narrative-focused questions. And as I worked harder on drafting questions that were one fact in the question, so very narrow focus. So if somebody admits or denies it, you know what they're admitting and denying. And then facts that are, the best way I heard somebody describe it is, my questions on cross-examination are declarative statements with a request for affirmation. You got up that morning, right? Or not even using the tagline, just using intonation. You got up that morning. You got dressed. You put on, you picked up your car keys. You got in the car and you went to the mall. Whatever the fact pattern might be, that's the first thing. If you ask good questions that are well-crafted and narrow, it makes it hard for the witness to bob and weave out of them. That's not the end all. Sometimes you have witnesses that are completely unruly. They won't answer the question that you ask. They try to bob and weave out of it and ask a question that they want. And I've used a variety of tools that I think other people would recommend too. So, when the witness is narrating something, are you done with your answer yet? Okay, thank you. This is the question I asked. I'd like you to answer my question now, and then re-ask the question. I had recently read a book where the author, trial lawyer author named Shane Reed, talks about never asking the judge to step in. So tell the judge, Your Honor, instruct the witness just to answer my question. His view is when you do that, it looks like you've lost control and you're better off just asking a question until you get an answer. His response is more nuanced than that, but I thought that was fascinating. I have at times intervened and asked the judge, but more often than not, if you ask very straight, narrow questions that require yes or no answers or I don't know, if you ask questions like that, the judge and jury sees what's going on when a witness is evasive, and the judge will step in. I've seen judges do that to witnesses where they say, hey, he's just asking you a yes or no question. Please just answer the question. And when they get really impatient, then they'll lean hard on them. But if you as the lawyer do your job of asking single fact questions that are, like I said, a declarative statement with a request for affirmation, it's hard for anybody to let them, go broad. I've also, you told the witness, on redirect, your attorney can ask more questions if they want, those kinds of things.
What would you say is the most common tell that you see from a witness on the stand who's not telling the truth?
Two things I think are the hallmarks. Number one is this filibustering. They have to explain every answer with something. I wish I had a good example, but you went to the mall on Tuesday. Well, I had to go to the dentist and then I did this. And they're explaining a whole bunch of excess facts to mask something. That's number one. Number two, you see it in eye contact. They won't look at you. They won't give eye contact to the jury. They'll look away a lot. And it takes a little bit of time in an examination before you can see when that's happening, because sometimes people are nervous and they don't want to give eye contact, but but once you get into a comfortable rhythm and you're asking regular questions and regular non-threatening questions, and you see the witness answering them like you would expect a normal person to answer a question, and then you start turning up the heat, and then the eye contact goes away. They're looking down and away and those kinds of things. And obviously it differs witness to witness, but you will, as you watch the witness you're examining, you can get a feel for what they're doing, which is another reason that, a lot of trial practice experts will say, don't be tied to your notes. When you're tied to your notes, you miss out on a lot of these things that are happening right in front of your eyes.
Just generally speaking, how astute do you believe that most jurors are in being able to pick up when someone's not fully truthful?
I think that's one of the things juries are quite good at. And I don't know if it's because there's just something to do with having a collective group of people that are looking at a set of facts. But I find it very interesting that jurors, you poll jurors afterwards and I just didn't like that guy when he said this on the stand. It just didn't seem right to me. And these things. And even about the lawyers, when they think that the lawyers are hiding something or being overly picky about something that they shouldn't be about, I think they pick up on that. But I do think jurors pick up on dishonesty. And I think one of the things is if on cross-examination in particular, if you ask the questions the right way, then watching how somebody responds to them, I think, is very telling. And the juror's job, they're just there to observe. So they're watching all of the things that are happening, and I think they can feel it.
Let me ask you a little bit about your current practice. And I did take a moment to read your biography on your website, and I found it to be very helpful. But the picture that emerges for me is that you're called upon, possibly fairly often, to parachute into a brand new case that you have not worked on that's very close to trial, maybe in the 11th hour, and it's one of those bet your company type disputes where a company's very success could be hanging in the balance. Is that pretty accurate of some of the cases you work on?
Yeah, I think that's fair. I get called into cases a lot of times when a lot of that pre-trial litigation has been done and we're trying to decide, like, trial strategy to get it ready for trial or to bring it to trial.
What is the experience like to just parachute in a brand new case and learn a whole new set of facts, cast of characters, issues, underlying dynamics, motivations? What is that like?
Well, for me, I like doing that. I mean, I like having cases from the beginning, but it's interesting to come in and step in and to see what's been done. You got to be careful, depending on how you're coming in, not to second guess the work that was done beforehand. But you now have, one of the things that makes it easier is not the right word. One of the things that makes it sort of streamlines the process a little bit is all this work has been done. The facts are there for you. Whatever's come out in the deposition, that's what you have. Whatever's come out here, in document discovery and in written discovery, all of that stage has been set for you. So it's streamlined in the sense that your focus is simple. So you have a client, there's maybe a theory of the case that's been developed thus far. Perhaps some themes have been shaken out, although a lot of times, there isn't a lot of thought to that. But now it's to take all these raw ingredients and figure out what is the theme, to use an entertainment term, what's the through line of the story that we're trying to communicate? What are the facts that we can marshal that support our side? And what do these facts tell? And what are the ones that, the facts that are against us, where do they lead us? It is nice to be able to have all of those ingredients there for you and, just work with what you have, as opposed to the additional part of trying to figure out how to develop facts, when you have a case that's just started out. Both have their advantages, obviously, and some have their disadvantages, but it is, it's nice to be able to sit down, go through all the deposition transcripts, go through the discovery that's been done, and then try to pick up, where the story is and where you're trying to take it.
To what extent has AI assisted in helping to synthesize some of the evidence that's already been developed by the time you get a case?
I have never used any AI in a case. I will give one caveat. I did one time have a case where there was a case involved a partnership dispute, but there were some employment law questions. And I went to AI to try to evaluate, some aspect of the claim. And I didn't find that experience very valuable. Now, that was a couple of years ago. I know these tools advance so much now, and I think there is a place for AI. But in terms of, maybe I'm old school about this, I don't read summaries. I read the material. I read the transcripts. I read the documents. I go through because I want to develop what I need to develop and the thoughts that I have about something, and not have something else do it. Because not maybe the AI might do a good job with it. I don't know. I can't speak to that. But what I don't know is I may always second guess it because I didn't experience it firsthand. I don't know if that's a helpful way to explain it. But my feeling is I want to have reviewed the materials and I want to come up with something out of what I see. Now, what AI, maybe this is an area where AI comes in. What I have had experience now doing is using focus groups, and talking through a case with a focus group gets, a sounding board of other people that they don't necessarily tell you, I think you need to do this, but they have questions that you then realize, all right, I have to fill this gap because there's a question. I think that works very well, and it's still kind of iterative. I think putting things into the black box of AI, I don't know how that I would feel about the output of that. I would be open to trying AI in some limited areas in that regard, but I don't know. Are you aware of attorneys that have used AI to develop lines of questions or refine theories?
No, I have not, but I believe it's well within the capabilities of AI. In fact, I could envision someone using AI in the courtroom to have it develop cross-examination questions in real time based on the information that's being elicited.
It would be interesting to see how that works out. And I've been very impressed with what these models can do and to be able to use it for, an examination or something, definitely seems like it's possible.
The most interesting question, though, to me is, do you think that there will come a time when AI will actually replace the trier of fact in civil litigation?
I don't know. I think the problem in terms of just say raw analytical, like I've heard these 7 facts and these 11 facts and, how do they fit in terms of this element? I don't see AI changing the trier fact to that, because I think there's a big component of juries and judges in bench trials using their life experience, the emotional factors that, to my understanding right now, AI can't really tap into in ways. So there is a sort of intuitive aspect of what happens, and intuitive may not be the right word. Emotional might be more of the right word, but there's that sort of heart side of deciding a case and weighing facts. So let's say you have a divided issue, right? Case that goes to trial 9.5 times out of 10. If you've got good lawyers on both sides, the case is not it's a close call. Otherwise, the case would have settled a long time ago. So if you're there, and it's a matter of there's 4 facts that support this element, there's 4 facts that go the opposite way, that controvert the element. How does AI pick between those? And that's where I think, a human is more equipped to do that than AI. Could AI make a decision? Sure. Is it a decision that we want to rely on? Do we want to take the humanity out of the decision-making process? That I don't think so.
Well, fortunately, as it currently stands, people have a constitutional right to have live flesh and blood people, the triers of fact.
You've got me very excited about this topic. What might be fun to do is take a set of facts, like even if you took an old case that was tried or a mock case file, if AI was even set up to be able to do this, but have, like, say 2 or 3 focus groups and have 2 or 3 AI models, and all 6 come up with, what's the outcome of this, and get a sense of, how does the AI look at it? How do the people look at it? And are the outcomes the same? That would be an interesting study to have. And by the way, if that ended up working, conducting a focus group it's not obscenely expensive, but it's an expensive process. If that could be done something through AI, that would be very interesting. But then AI, I suppose, would have to listen to testimony as well as just ingest written testimony and know what's admissible or not admissible and those kind of things. But it's a very interesting and fascinating set of technological developments.
It is. Just on the issue of admissibility, one of the touchstones there is the weight that should be given to a particular piece of evidence, how probative it is. And that's something that AI can discern on its own. It can discern, whether or not to give it much weight. The other thing is jury confusion, and that's out the window with AI. So some of the admissibility rules that typically come into play in a civil or criminal trial don't quite fit the paradigm of AI. But before AI could ever be used as a trier of fact, the parties would first have to stipulate to it, of course. But I think the state of the technology needs to be better in order for people to have a sufficient level of comfort with the outcome. I think that AI is very good with logical tasks, with probabilities, and that certainly plays a role in the decision-making. But as you pointed out, there are a lot of soft, humanistic factors that go into play that AI is really ill-equipped to respond to.
Right.
So I think that's going to be the big hurdle in the short term.
Yeah, I think you're right. And you said something that struck me a bit. AI's programming ultimately is, like you said, statistical probabilities. It's ingested all this data, and based on all of this that the model's been trained on or whatever, there's a 86% probability of X and 96% probability of Y, and however it does its math. I can't imagine parties would want something that's making decisions based on just mathematical probabilities. I don't know if we unpack the human brain, if the human brain's neural network is also mathematical probabilities. That's beyond me. So, I don't know if AI ever gets to a point where it can actually reason about things as opposed to just use the probabilities.
Do you ever put on witnesses whom you haven't prepared yourself?
Yes, I have done that, but generally the people that I've entrusted to do the prep, attorneys that I work with and trust and understand what the mission is, I have put people on the stand that I haven't prepared. It's very rare, and they're usually not mission critical witnesses.
Tell me a little bit about the training program that you mentioned at your firm.
So what I felt like I was missing was not having somebody who could tell me I'm the young pup and they're going to tell me how to do all of these things, or where I made a mistake. Then what I wanted to do was to create an environment where I could teach what I know to my team and then give them an opportunity to actually try it out. So I built this curriculum that's designed around the idea of actually having the associates try the things that we would do, almost like what you'd have in a trial advocacy class in law school, almost exactly like that, right? So we do a direct exam, we do cross-examinations, we do openings, closings, and at the end of it, we're going to do a mock trial. And it's the program's designed to do it to cover 2 years, so there'd be 2 years. The first year is what I would call the basics. So it covers those things, those trial practice skills, cross-examination, all of that. And it covers my philosophy on how to prep a case from start to finish for trial, how you build your case, the logistical things of where you keep information and how you track the steps that you're doing. So it covers all of those things, but the idea behind it is to give the associates practical experience. And that's also for two reasons, not just for the absence of mentorship. That's one thing, but there's a lot of times not a lot of chances for younger associates to really try things out, right? As we all know, there are fewer and fewer cases get to trial. So I like to, when cases get to trial, I like to maximize the opportunities everybody on my team has to do things in the trial rather than just, carry files to and from the war room or whatever. So my program covers as much of that stuff as possible. How we do these things. I put together a manual over the years, things that are excerpted from other places. It's stuff that I've read and picked up that works that I've incorporated into my procedures. And I've created these operating procedures that we can use, standard operating procedures that we can use for a variety of things. So for me, it's made a big difference. So training people on how to do that and then telling them at the same time. So that's the nature of the program. And we've started running it. We've got our first direct and cross examinations coming up this year.
What is the most common mistake that you see from other lawyers who are cross-examining witnesses?
I think the biggest mistake is not paying attention to what the witness is saying. I had a case a few years ago where it seemed like the attorney doing the cross-examination had an associate or a partner, somebody else at the firm, the questions that they were going to ask. And the attorney asking the questions on cross-examination of my client was just going through that list, not paying attention to what was said. So I'm not exaggerating when I say this. At least 3, there might have been a 4th time, at least 3 times, my opposing counsel tried to impeach my client, who was the witness on the stand, impeach my client by suggesting that an answer that they gave was different from, whatever, a prior inconsistent statement in their deposition or something along those lines, when my client had testified exactly consistently with the deposition. So it was something like, you just said that the traffic light was red. Yes? Do you remember taking a deposition in this case? Oh, yes, I remember taking a deposition. And all those lines of questions that you would ask. And then on your deposition, you said that the traffic light was red, didn't you? And he say, yes. And the lawyer didn't even realize it. They just went on to the next series of questions. So they reinforced the testimony, and this was a trial in chancery court. So it was the chancellor that was seeing it, but it had a pronounced effect, I think, on the outcome of the case in not good ways for my opponent.
Was that in Delaware?
Yeah.
So I'm going to now ask you the capstone question. Have you ever asked that one question too many?
I have been lucky that I've not asked the one question too many. I've asked, as I talked about earlier, some very bad questions that have enabled a witness to, retell large segments of the story that they were trying to tell to sometimes damaging effect. But I've never asked. I have taken the rule that you can break, but the rule that, a lot of people like to follow of ask questions that you know the answers to. And I've tried to craft questions where I was sticking within those things, knowing what I wanted to get out of them. I've never been in a place where I felt like I needed to get a witness to say something, say something on the witness stand that I haven't heard them say before that I needed in a way. So I dodged that bullet, fortunately.
Can you tell our listeners how to get a hold of you?
Yes, you can find me at Pryor Cashman. My firm is, the website is www.pryorcashman.com. My email address is right there on my bio. You can find me there. The firm website's the best. I'm on LinkedIn as well. You can find me there. And I'm also on X under Thomas Vidal.
Thank you, Tom, for joining us.
Thank you very much.
Join us next time when our guest will be Jay McAllister, CEO of Paragon Tech. This has been a production of WKNOW.